Many of us have been summoned for jury duty, and some of you have likely even been seated and served an integral part in our judicial system. In today's Injuries Are Personal with Reynolds Law, attorney Carl Reynolds joins us via Skype to continue our conversation about what you aren't allowed to know as a juror, but wish you did. Good to see you, Carl.
Great to see you, Stephanie.
So last time we spoke, we talked about how juries don't get to know about insurance coverage or the police report in trials involving accidents. And today you're going to explain permanency requirement limits. What does that mean?
Well, we have a tort threshold in Florida. Many people have heard of no fault in Florida. And what that means is insurance pays no matter who's at fault for initial medical bills, but you still have to prove fault in order to get recovery from the other party. But where the legislature gives in paying medical bills, no matter who's at fault, they also take away, which requires a showing of permanent injury in order to get pain and suffering damages. And I think a lot of juries don't realize that if they say no to permanent injury, even though the victim has suffered pain, inconvenience, suffering as a result of the accident, if they say no, then that victim never gets compensated one penny for that pain and suffering.
And you said that's something that many jurors don't know. That's not something you're allowed to explain in the courtroom?
It's explained, but I don't think they realize the ramifications in the end game or their verdict because they see the medical bills, they see future medical bills, and those all go to pay for other people. They don't actually pay the actual victim. It just makes them square. It doesn't actually compensate them for what they've been through. And unless there's a finding of permanency, they aren't compensated for that pain and suffering. And so, all the doctors in my cases, when we go to trial, they've all testified that my client suffered permanent injury. But the defense usually hires a doctor that says quite the opposite. So there's a battle of the experts, so to speak. And if the jury sides with the defense, that victim never gets compensated a penny for their pain and suffering. In other states, there isn't that threshold. And so they get automatic pain and suffering consideration. But in Florida, we have that threshold. So I think it's important consideration that I think juries, overlook sometimes.
Yeah, and I think I would actually side certainly intelligence-wise with you, because if I've had any pain and suffering, even if it was 2 years ago, it's permanently part of my being. So if I have to have something permanent, even if it's not a physical injury, you can't take away what I've been through.
Right, and pain and suffering is broken down in past and future. So if you feel like, look, this person's healed up pretty well, they've dealt with it, well, then you just provide compensation for the past. So that's one of the things that I think jurors often overlook. And also the fact that oftentimes, because we talked about insurance, we talked about who's at fault, oftentimes jurors don't realize, because they're not allowed to know, about negotiations that occurred in the past leading up to the trial. A lot of times they ask, well, why is this taking so many years to get in front of a jury? Who's being the difficult one here? The problem is we're not allowed to tell you that the insurance company either denied the claim or is offering, $5 on a case that, has a value of $50,000. So any settlement negotiations are all confidential, and juries never get to hear about them and why it's taken so long to get to this process.
Okay, and would you like the jury to know that? I mean, does it bother you as a lawyer that they can't know that there was a settlement offered and it stunk?
Absolutely, because oftentimes they think maybe it's my client being the difficult one and being the juggernaut and forcing them to be inconvenienced by being on the jury, when in reality, it's the other way around. There is mandatory mediation in the state of Florida, and usually those mediations, most of the time, they would result in some sort of resolution. But in this pandemic era where we can't get to trial for many months out, sometimes more than a year out, insurance company, what people don't realize is they're making money with your money. When they owe you money, as long as they're holding on to it, they're making interest on that money. So the longer they can hold on to that money, the more they're making. And since I can't force a trial for many months out, sometimes a year or more, they make low offers at mediation. And so it's not that my client's being difficult or that we're asking for the moon here. It's that there's not a resolution reached. And oftentimes it's because the insurance company doesn't even cut pay enough to cover the bills.
Right.
The problem is they can come to trial and say, hey, pay his bills. Now they seem eminently reasonable, whereas before trial, they never even made an offer close to that.
Yeah, and obviously, I'm sure your client would like it to resolve as soon as possible so they can pay those bills. That is for sure. All right, lots of information about what really is going on in a jury and what we don't know that's going on. For more information about any legal questions, Carl's always happy to help you out. You can go to injuriesarepersonal.com to contact him. We'll be right back.